Hello, class. It's a pleasure to welcome you back to Business Law 2 after our unexpected extended spring vacation. As I indicated, I will try to each week present a certain number of vignettes, like this one. And for each of them that I present, I'll need you to respond to the prompt that appears below the video and which I'll tell you about at the end of this video. Okay? So without further ado, I think we'll just basically dive into our next topic, which is corporate directors, officers, and shareholders. Right? Again, we've talked about corporations, and now we're going to talk about how that corporation operates, and how it should operate, and some of the pitfalls that we need to be conscious of. Right? So we'll begin with a bit of, since it's been a little bit of time, we'll begin with a little bit of a refresher on what a corporation is and what is it that makes it special in the context of our studies here. And so John Marshall, one of the first Supreme Court justices, once said, "A corporation is an artificial being, invisible, intangible, and existing only in contemplation of law." A corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. Why so dramatic and poetic? It's an attempt to explain the fact that we grant a corporation special status. And we talked a bit about that, right? Some of the features of that include, for example, a corporation has to be operational under a statute, generally a state statute. In almost every case, it will be under a state statute. There are a few corporations that operate under federal charter as well. But generally, it'll be under state statute. Its defining characteristic is its unmitigated, well, with a couple of exceptions, limited liability of all of the owners in their capacity as shareholders, whether or not they are also employees of the company and separate from any protections they may have as employees. Indeed. Also, the choice to retain earnings or to pay profits in the form of dividends. So instead of pass-through taxation, there are options available to a corporation, whether they would, if they're a C corporation, to retain those earnings or to pass them through as dividends. And of course, retained earnings can be invested and become more profitable for the corporation. And that would be money that, if it were distributed to the shareholders and the company needed more investment, it would have to be basically reinvested by the shareholders after taxes. And so this kind of avoids that. Agency liability is for torts that are committed by the corporation. Again, that generally involves employees and other agents, and generally involves sums of money to be paid. In the case of crimes, the corporation can be guilty of a crime, but in fact, obviously cannot be jailed. They could be fined, but they cannot be jailed. Employees, however, of corporations can be jailed, and so employees must be careful not to break criminal laws while they're in the process of working for the corporation. And so this will bring us, briefly by way of review, to the principle of piercing the corporate veil. The owner's violation of certain statutes or certain principles, for example, the commingling of corporate and personal assets, might, under certain circumstances, result in the bad result of the owner's personal assets being available to satisfy judgments and liabilities of the company. That's called piercing the corporate veil. It defeats the limited liability that is normally granted to the owners. All right? So we've got some of the review of our principles of corporations out of the way. Let's talk a little bit about what it means. What does he mean when he says it's an artificial an artificial being, or to talk about it as a corporation as a fictive person or a legal fiction, right? Uh, the Sir Edward Cook has another quote, I guess, that we'll bring in line to talk about corporate officers, directors, and shareholders. All right, he says that corporations cannot commit treason nor be outlawed because they have no soul. Right? Essentially, corporations are legal fictions, right, that operate through agents as if they were natural persons. But obviously, they cannot act and have legal effect without the action of natural persons. A corporation is not a natural person. It has its own separate existence. And so this chapter is about shareholders, directors, and officers. The setup, right, of how power flows. A shareholder, as I mentioned before, is an owner of the company. All right, they may be a very tiny owner. If it's the case of any of you that may own shares of public companies, most likely, unless I don't know something, that you're most likely an owner of a tiny percentage of a public company, or you may be, if it's a small family-owned company, maybe you own a larger portion, right? But you're basically being a shareholder means that you have a claim against the future cash flow of that company, right? And a portion of that you should be entitled to it. A director is the party that manages the corporation in its, I'm going to say, corporate capacity, meaning that the board as a group, generally it's a group. It's possible to have a single director of some companies in some states, but as a group, they manage the company, right? The directors have direct hires that are called officers, right? And these officers basically execute the management of the company under the supervision of the directors. And then there are the employees, who are agents of the company that are hired generally by other employees or by the officers of the company, right? Each role has certain rights and duties, as we've discussed throughout, and we've grounded a lot of this in what are agency principles, right? So, agency principles, as a quick reminder, right? Agency principles underlie all corporate action. Agency principles underlie all corporate action. In other words, a corporation cannot act without an agent. If something happens and there's no agent, then the corporation didn't do it. Someone else did it, right? Meaning if you're going to put liability on the corporation, there must have been some agency involved because the corporation doesn't have hands, it doesn't have a mind of its own, right? So remember, an agency relationship arises where a servant, who is the agent, the servant agrees to act for or instead of the master, who is the principal, right? So we need to keep that in mind because not everyone on our little chart is, in fact, an agent. Generally speaking, shareholders are not in the position of agents. There is no agency with respect to shareholders, right? With regard to directors, they are not individually agents, right? Because, as we'll see, it is the corporate capacity of that board. It is in their corporate capacity that they are a servant to the principal, right? The principal, in this case, is the corporation, INC, represented there, right? It is the principal for each party that is an agent in this case, right? The officers are agents, and the employees are generally agents, right? So each of these parties has their own sort of spot in the relationship. Obviously, employees are subordinate to officers. Officers are subordinate to directors, and the principal is in fact subordinate to the directors. But in fact, when it comes to liability, the directors are still the servant of the principal, right? So that's enough for now. I'm going to continue with a question that appears at the end of this video. Please reply, and I'll talk to you soon.